All right, welcome to chapter 14. This is going to be the last chapter lecture. I think I skipped chapter 12 and chapter 15. There will not be a lecture on those, so this is going to be the last one. It's not necessary to lecture on those. You can read the chapter and look at the PowerPoints on your own. But we're going to talk about legal liabilities of law enforcement officers. Just getting sued. Legal liabilities or civil liability is getting sued, which means the officer might have to pay money, but usually it's not the officer that pays the money. It's the government that pays the money because the government has deep pockets. They got these big insurance policies or big taxpayer-funded budgets. So, you sue a cop, he might make 30, 40, 50 grand a year. An attorney's not going to invest, a $300,000 lawsuit into suing a police officer because that police officer is never going to be able to pay it. You can't get blood from attorney. But what they really go after is those deep pockets, the state and federal agencies that employ these officers. That's where the real money comes into play. Just like you've seen the signs that say, hey, look, 18-wheeler wreck, give me a call. They don't say, hey, did you get involved with an 18-wheeler wreck and it wasn't your fault? It just says, I want your 18-wheeler wreck. Because even if even if it is your fault, they're going to try to get money because they have a minimum of $3 million liability insurance policy on each one of those commercial trucks. So, they might just go after the 18-wheeler. You ran into the 18-wheeler, and they'll say, oh, well, his taillights were dirty, and try to get him to settle for 10 or 20 grand, just to get it out of the way, because you're going to spend a lot more than that defending a frivolous lawsuit. So I'm not going to get into the issues with frivolous lawsuits, but they are there. But you have civil liability, you have administrative liability, which is like if you get fired from your job or suspended without pay or demoted. Those are all administrative liabilities that are administered by the actual department. And there are protections there, so I actually consult sometimes law enforcement officers who have been mistreated by their departments, and I've even assisted and still am assisting on suing departments for like whistleblower violations and stuff like that. An officer who does the right thing and then gets punished for it. Civil liability, administrative liability, and then of course criminal liability. We're seeing more criminal liability for officers getting arrested for using excessive force. We would be lying to ourselves if we didn't say that was partially inspired by press and protest and riots, and we'll say that could be a good thing or a bad thing depending on the circumstances. I'd hate to see a police officer who didn't do anything wrong get arrested because of public pressure, and I think that has happened in at least a couple of cases. And you think, oh, this guy's too pro-police. No, actually, the reason that has happened is because there's been way too many cases where the police obviously did it wrong, and the government doesn't do anything about it. They're like, oh, everything's fine. We're okay with this. You can't tell us how to do our jobs. Yes, we can. We pay you. We fund you. We're your boss. We can tell you stop shooting for no reason. You have to. You can't use excessive force. And George Floyd, I don't know when you're watching this, but George Floyd really inspired a lot of people to get involved. A lot of white people actually finally said, okay, enough's enough. This is a slow, methodical murder. At least that's what I saw in the video. And anyway, that's going to result in significant civil liability, and it resulted in criminal liability, where they finally said, okay, not only are they going to arrest the guy who did the murder, but he was protected while committing that murder by 3 other officers. So you didn't have one bad cop and say, oh, there's just one bad out of 99. No, you had 4 cops on that scene that were bad, 1 doing the dirty deed and 3 protecting him while he did it. So it's about time that somebody stepped up and sends a message to law enforcement. Just because you're not doing it doesn't mean you're not guilty as hell too. So it's good that they're doing that. I don't know if those other 3 officers will be convicted, probably not, but I think the officer that committed the homicide, I forgot his name, don't care, but the guy that murdered George Floyd, I think he'll spend the rest of his life in prison. We have a developing situation in Louisiana right now with another gentleman. Hopefully you'll read about it. I believe his name is Ronald Green. I don't know when you're watching this video, but I predict that today's date is Saturday, September 26, 2020. I predict that it's going to explode. It was another murder by a Louisiana state trooper, and when the body cam comes out and the evidence comes out, you're going to see that it's not limited to Minneapolis, Minnesota, it's other places. So there should have been criminal liability, but actually the officer just killed himself, ran his car off the road and died a few hours after being notified that he was going to be terminated 16 months after he did the murder, or what I think could have been a murder, but I haven't seen it. They won't show it to us. They're hiding it. Well, if they thought it was a good shooting, they would have released it. Not a shooting, I'm sorry, it was a beat to death. They beat the guy to death. If they thought it was a good beating to death, they would have released it, but they're not releasing it. They're hiding it. So, history of state police that I have, I am a retired state trooper in good standing, retired and with a great record, but they have some bad apples and bad leadership. So, from Mike Edmondson to Colonel Reeves, who took over, garbage leadership, and now the entire organization is paying for it. So, all right, reasons to sue. You can sue for basically anything. False arrest, excessive force. There's been some pretty bad examples. Like highway cavity searches. You can't do a body cavity search. You can't stick your digitals, which is the medical term for fingers, inside another person's rectum or vagina and look for stuff. That's called a body cavity search. You better have a warrant, and you better have a damn good reason for doing it, because even if you do have a warrant, you're still going to get sued. In fact, in Deming, New Mexico, they decided, hey, we think this guy's got drugs in his ass. I'm sorry, let me be collegial. Drugs in his rectum. They think, and so their evidence of that was he was clenching, appeared to be clenching while standing, and a drug dog alerted. Well, maybe the drug dog alerted because they smoked weed in the car, whatever. Anyway, they searched him, they searched his car, didn't find anything. He said, well, it's got to be here. Only place it could be is in his ass. So they got a search warrant for his rectum, and then they started a field day. They started, I think they did 3 or 4 digital penetrations with a doctor. They took him to a doctor, well, actually 2 doctors. The first doctor said, I'm not doing that. This is unethical. They should have said, well, maybe this is a clue we shouldn't be doing what we're doing. So they took him to another doctor, and that doctor said, yeah, it's Saturday night. Let's have a party. So he started sticking his fingers in his rectum, didn't find anything, did an x-ray. X-ray didn't show up anything that didn't help them find drugs, so they said, let's try an enema. So they did 2 or 3 enemas. I can't remember. If you don't know what an enema is they stick a probe device in the rectum and turn on a water hose and flush you out. And they did that 2 or 3 times, still didn't find anything. And then finally they say, you know what? We got somebody who might have drugs. We don't like drugs. He shouldn't be using drugs. He shouldn't be possessing them. Then they gave him drugs. That's right, the doctor gave him drugs, sedated him, and gave him a colonoscopy. So that means they went into his rectum. Can't see how wide my arms are. I'm 6 foot tall, but about 6 feet into his rectum, looking for drugs with a camera. Never found anything. Finally let him go after a 12-hour ordeal, and then said, yeah, we did it right. There's nothing wrong with what we did. We can do it again. Well, picture this. You buy a used car. Somebody smoked weed in that used car. The drug dog might alert on that because you ran a stop sign. You just left the gym, and it's leg day, and you're standing funny. And I don't even know what standing while clenching might be, but you get subjected to all of the following. People sticking their fingers in your ass multiple times, sticking a water hose up your ass and turning it on multiple times, and finally giving you drugs and a forced colonoscopy, which is a surgery, and finding nothing, and then finally letting you go. So in all, there was like 8 rectal procedures between the x-rays and the fingers and the probes and the colonoscopy. Wait, there's one more. There was a 9th rectal procedure, which was they sent him a bill for $5,000 and said, if you don't pay it, we're going to take you to collections. And again, the city of Deming, New Mexico, which I stopped there one time just to see what it was like and, take a picture, but I made damn sure I wasn't getting pulled over, obeyed all traffic laws. In fact, if they would have tried to pull me over, I probably would have ran. I'm joking. Yeah, I probably would have ran. Anyway, they ended up, the city said, yeah, we did it right. And turns out within a few months, which is really, really fast for a lawsuit, they said, you know what, we're going to settle this one out. And they gave him $1.8 million. Not enough for me, but it was apparently enough for David Eckert. Google it. David Eckert, Deming, New Mexico, cavity searches. They said they did it right. Now, they may have done it in the past and they may have tried it, but I guarantee you they're not doing it anymore because the city can't afford it. It's too expensive. Okay, moving on. Legal liabilities, they call it a reality of modern day policing. If you do your job, you're going to get sued. And yes, there's a chance you're going to get sued. I've been sued a couple times as a law enforcement officer, once for not doing an investigation properly, and basically the court ruled that the investigation was done properly, and I actually thought it wasn't done properly. I thought it was garbage investigation. They messed it up. But again, you're under no there's no legal liability for not doing a good investigation. It's like going to McDonald's and saying, I'm going to sue you because, my lettuce isn't crispy enough. They don't have to provide excellent service. It's the same thing as law enforcement. And with that said, I didn't think the investigation was proper because I didn't do it. I was at the end of my shift. I showed up on scene, said, hi, do you need anything? And they said, no. The supervisor said, go home. So-and-so is going to handle the investigation. So I didn't even do it. And that investigation, it was not handled properly. No pictures were taken as they should have been. It was serious injuries. And anyway, I felt bad for the person who sued, but again, it just wasn't it. I was also involved in a crash. Patrol cars are just like 18-wheelers. They have a big, huge liability policy. So if you're involved in a crash, especially when you're going to a scene, running your lights, you're a high-risk vehicle. You're going through intersections with their lights on. That's why just because you got blue lights and sirens doesn't mean you get to drive carelessly. And anyway, I made a mistake and didn't properly clear an intersection, was involved in a crash, and got sued. And, it was settled before it even went to trial. So it happens. All right, the different liabilities, you got civil, which is money, criminal, which is jail, probation, all the stuff we've already talked about, and administrative penalties like losing your job. So moving on, let's make sure we understand. So police are special. So I told you cannot, a regular citizen can't violate someone's rights because the constitutional rights are there for the government. A citizen cannot use excessive force. It just doesn't exist. Now they'll get if I beat somebody up on the street for no reason, I'll get arrested for a violation of state battery laws, but it's not a federal crime. For instance, but with police it's different. So the federal government has a crime that says if you violate somebody's civil rights under color of law, which means you're a police officer acting under color of law, you can be arrested. That's a criminal offense covered under Title 18, 242, I think it is what it is. So anyway, it's a criminal offense, and also they have it covered under the civil code. So you can sue in federal court to get money, and you can also possibly the officer can be arrested. You can't go to the FBI and say, hey, arrest that cop, he did me wrong. It doesn't work that way. They kind of pick and choose their own cases. But that's what happened with Rodney King. Those officers beat Rodney King with sticks, and they think they acted within their training, and they probably did. I think the training at the time was if you tell somebody to do something that you're trying to arrest and they don't do it, hit them with the stick until they do, and that's what they did. Mr. King wasn't listening. He didn't do what they told him to do. He kept trying to get up while he was laying on the ground or moving, so they just hit him with a stick until 50-something times. Well, they knew or should have known that that's not right. It's just not right. It's wrong. It's criminal. So they got found not guilty in state court, but under federal court, they said, well, your police officer's acting under color of law. You knew or should have known that you were violating his Fourth Amendment right to be free from unreasonable search and seizure. An unreasonable excessive force is an unreasonable seizure, so therefore it falls under the protections of the Fourth Amendment. So they got convicted in federal court and sentenced to prison. So you got Title 18, which is a criminal code in the federal system. Then you have Section 1983, which is the civil rights law under, not the year 1983, but the Section 1983, civil rights law involving law enforcement officers. So again, if you violate someone's rights, in fact, I'm involved in I had a guy come to me and say, hey, I had a state trooper arrest me for no reason. I was like, what do you mean no reason? And he said I was drunk, and I wasn't drunk. Well, all drunk, I've arrested hundreds and hundreds of people for drunk driving. They all say they're not drunk. I said, let me see the report, let me see the video. Well, there was no video. So I said, well, let me see the report. And I read the report, and actually the report as written, he wasn't drunk. I mean, he was arrested illegally. He was arrested without probable cause. So I felt bad for the guy, and really nice, seemed like a nice guy. And anyway, I put him in touch with an attorney and did an expert analysis. Anyway, that case been they filed a lawsuit, and it's still going on. It's been going on for like 5 years, but it was an arrest without probable cause, and now it's in federal court. Basically deprivation of rights under color of law, so that can be subject to civil liability. How much civil liability? Maybe none. The court may say, you know what, it's okay to arrest people who are not drunk for drunk driving. I don't think so, but the courts could say, and the reason the guy got arrested, he admitted that he had 4 beers at dinner 4 hours prior to that, but that was it. That's the only evidence they had. I mean, that was it. It was like, it's like me, I pulled people over before. I said, hey, you been drinking? Yeah, I've been drinking. How much you had? Well, he said, I had one guy say he had 12 beers. It's like, this guy's holding his liquor pretty well with 12 beers in him. And I said, okay, well, let me do a field sobriety test. Well, he passed it with flying colors. I was like, look, man, you told me you had 12 beers. When did you start drinking? He started drinking at like 6 o'clock in the morning and was fishing all day and drinking. Well, if you do the math on it, when I pulled him over, it's 2 a.m. So it was that 20 hours or so after? He didn't have any alcohol in his system, even though that particular day or that morning when he woke up and he hadn't been to bed yet, he had 12 beers. Well, that's he was truthful, but he wasn't operating a vehicle while intoxicated, so I did not arrest him, sent him on his way. So anyway, the guy arrested him for no reason, and I thought it was wrong and evil, so civil suit's going forward. To prove civil liability under federal law, you have to prove that the defendant was acting under color of law. So a cop beat somebody up for no reason. In fact, we had Lake Charles Police Department, a guy named Officer Hammock was convicted of this because they finished up a pursuit, pulled the guy over, he put his hands up, tried to pull him out of the car, and then Officer Hammock reached over and just started punching the guy for no reason. On video, and anyway, he got sentenced to federal prison because he was depriving someone of their civil rights, and he was under color of law. So contrary to that, you got the George Zimmerman shooting where he shot and killed Trayvon Martin. Okay, so whether you agree with whether Trayvon Martin shooting was justified or not, I'm not going to get into that. There's we don't have enough time here, but he was not charged federally. He wasn't charged federally, even though they might have wanted to, because he was not a police officer. He was not acting under color of law. He was charged in state court. He was acquitted. He was found not guilty. But they couldn't charge him in state court as well, like they could the Rodney King beating. I hope that makes sense to you. Let's see. An interesting case if you want to look at is called Town of Castle Rock v. Gonzalez. This is a case where a woman's ex-husband had kidnapped her 3 children, and she kept calling the cops saying, hey, took my kids, he's not supposed to have them. I've got a custody order, and it's supposed to be enforced, and the police just kept blowing her off. The police kept blowing her off for like the entire day until the guy actually showed up at the police department and started shooting into the building. Then the police decided to pay attention, put some bullets in him, killed him. But when they went out to his truck, they realized, this guy had already killed all 3 girls when they actually could have stepped in earlier, or at least tried to step in early and do something. And this is a landmark case. The Supreme Court said, hey, sorry, but we can't stop everybody from everything. So, and there's arguments on both sides of this, but again, what it boils down to is if you don't protect the rape victim, you can't be sued for that, or at least successfully. But there's what you're allowed to get away with and what's morally right. Morally, you should do the best job you can. You should conduct the best investigation you can. But that's not required by the civil courts. So I tell you that not to discourage you from doing your job well, just tell you what the current interpretation of the Constitution is by the United States Supreme Court. Let's see. Scott v. Harris, which is another really cool Supreme Court case. Mr. Harris was being chased by Georgia police, and he was going 130 miles an hour, rain, night, heavy traffic. Actually, the police probably should have called the chase off, but they didn't. They were trying to stop him for speeding. The guy that was running actually rammed a police car during the pursuit, so it was a pretty serious pursuit. And they got him, he got on the road, and they're doing 90 plus miles an hour is what it looked like on the video, and the police officer rammed the car, and he called it the pit maneuver, and ended up turning Mr. Harris into a paraplegic, permanently disfigured, never walk again, like from the chest or neck down. He's in a wheelchair, and for the rest of his life, he's paralyzed. He sued and said that the police used excessive force. And the first thing the government did was they said, we didn't use excessive force, we used non-deadly force. Hey, it resulted in what it resulted in, but it was non-deadly force. So the first question the Supreme Court had to decide was this non-deadly force? And if you would ask me, as a guy who's done a lot of patrolling, and we were never trained on the pit maneuver officially, we were trained on it, but not officially. It wasn't a pit maneuver. You do the pit maneuver, you don't want to go over 45 miles an hour because you're looking at more likely of an overturned vehicle, high speed, hitting another vehicle, going the opposite direction, hitting a tree. You just got all kinds of stuff when you start getting in those high speeds. Well, they rammed him at 90 plus, most is what it looked like. So that's not a pit maneuver. a pit maneuver is patrol intervention technique trying to stop a pursuit. It was deadly force. And the Supreme Court looked at it and said, yeah, you ram a guy going 90 miles an hour, he's probably going to die. And so they ruled that it was deadly force. And of course, they're like, Mr. Harris's attorneys are probably like, yes. But then, just because you use deadly force doesn't necessarily mean that the police are wrong. So the next step was that deadly force excessive? And the attorney on this one, who was suing the government, said he was just trying to go home. He wasn't really doing anything bad. And I believe, as far as I know, this was the actual first time in the history of the U.S. Supreme Court they watched a video, at least a dash cam video from a police car. So they watched it, and my understanding was they actually scolded the attorney, like, you kind of misled this court. It wasn't just he was running away. He was doing 130, wet roads, people all over the place, ramming police cars. So you put all that together. The Supreme Court had to determine whether that was justified deadly force, and they ruled that it did justify deadly force. They established a precedent that if you run from the cops and you put the public in danger, when I say the public, I mean the public, not the police. So if a guy's on a lonely road by himself doing 200 miles an hour and you chase him as a police officer, the police officer, are in danger going, at those excessive speeds. Of course, there's no patrol car out there that go 200 miles an hour. But there are some civilian cars that outrun cops that'll go 200 miles an hour. But that puts the police in danger. The police is not the public. So that's what they established. So if you're going through intersections or school, there's heavy traffic, you're running people off the road, you're doing excessive speed, you put all those things together, the Supreme Court said that is, they're allowed to use deadly force to stop that deadly threat. That was okay. So they established. It's a really interesting case. So I'm not saying, so basically what they said was if you're running from the cops and putting people in danger, you can shoot them with a bazooka and put a stop to the pursuit. Technically, we don't get issued bazookas, but the pit maneuver, ramming someone off the road, or even shooting, technically, under the right circumstances, would be okay. Of course, you got so many other factors. You start shooting at cars, are you going to hit an innocent bystander? Is there an innocent person in the car? So, all that would come into play. But, the Supreme Court did establish that deadly force is authorized for someone who's running from the police and posing a deadly threat to the public. Scott v. Harris, 2007. Pretty interesting case. A lot of videos on it. Different types of torts. You got false arrest, false imprisonment. And so you're like, what's a false arrest? Well, arresting somebody without probable cause. What's a false imprisonment? Detaining somebody without a minimum of reasonable suspicion. That's false arrest, false imprisonment. Putting someone in handcuffs without reasonable suspicion, or arresting someone, putting them in handcuffs without probable cause, is assault and battery. You're touching someone who doesn't want to be touched. And again, I tell my officers that I train, not my officers, I tell the officers that I train that if you touch somebody against their will, then you don't have that legal justification. You become Uncle Touchy. I make fun of them, like the creepy guy that goes around touching people with like a child molester, basically. So I try to stigmatize, don't do that. Don't put your hands on people unless you have legal justification, because, close your eyes and think for a minute. Do I want somebody touching me against my will? Running their hand through my groin, grabbing a woman and running the hand through in between her breasts and under her breast and feeling in her bra to see if she's got a weapon and so forth. Sometimes that stuff has to be done, but it's got to be done legally. And I found a lot of cases where the officers just say, yeah, I get to pat everybody down because it's officer safety. You know what, go to the mall and go pat down a 14-year-old girl in front of her dad and see how he wraps your jaw around the other side of your face. You can't do that, So they don't do that to people who can fight back. They do it to people who don't know any better, when the police are the actually ones who should know better. So again, don't be Uncle Touchy. That is assault and battery. Could result, I've seen criminal convictions for that, and also civil liability. Excessive use of force. If somebody punches you in the face, typically that doesn't allow you to shoot them. Now, sometimes it may, if you've ever heard of Chuck Liddell, the Iceman, if I would pull him over on a traffic stop and he tried to punch me in the face, I'm going to shoot him with a bazooka because I know what he's capable of. He's one of the hardest punchers in the history of MMA. Scary as hell. But again, that's an extreme example. But I've seen a fist can be a deadly weapon. But I've dealt with a semi-pro boxer who was a foot taller than me, outweighed me by 100 pounds, and if he would have tried to punch me or tried to get a hold of me, then there's a good chance he's going to take my weapon and win. Then that would, I might want to use deadly force or be authorized in using deadly force to prevent that from happening. Now, I did have that situation where I knew this man was going to resist, I wanted to arrest him, but I decided to wait. And I said, let me continue the field sobriety test, and I secretly called for backup on my radio. And but I knew what was going to happen. He got out. He was mouthy. He was drunk, and I knew that we were going to fight. But I thought the fight was going to take place when I told him he was under arrest, and that's exactly when it took place. When my backup showed up, I said, "Hey, you're under arrest," and that's when the fight began. But I had plenty of backup there, or at least really good backup. My backup was, I was arresting a guy who was like 6'7", a big black guy, and my backup was a big black guy. But my big black guy backup was actually much smaller than this guy, so it took both of us everything we had. I mean, I climbed the truck to get up to his head and wrap my arm around it and tried to Tim Burr him over, and we just stood there. But anyway, use of excessive force, deadly or non-deadly. Turn around and place your hands behind your back, you're under arrest is usually all it takes to take somebody into custody. Doesn't take beating them to death, or they don't get to get punished when they run at the end of a pursuit. Negligence torts, things that you're supposed to do and not supposed to do, like after we talked about failure to protect members of the public, essentially that's hard to prove, and there's usually no civil liability for that. There's a lot of liability for negligent use by police and motor vehicles. I've seen a police officer kill a family of 3 or 4 on his way home to meet his wife for dinner doing 122 miles an hour through an intersection. There's no way to defend that. We actually had a Louisiana State Trooper doing 111 miles an hour through a town with a low speed limit, no lights, no siren, and a guy saw a vehicle coming and there's no reason, he had no reason to believe that a vehicle's going 110 miles an hour, so he pulled out, and actually the trooper hit him, killed him. And he actually, that trooper stayed on the job, never got fired. I think he should have been charged with negligent homicide, but he wasn't. But anyway, obviously that was a major civil liability for killing that man. I don't know what the settlement was, but I'm sure it was a lot. But he didn't go to prison. He only got like a minor. He kept his job, and which I don't even understand how you keep your job after doing that. How do you write somebody a speeding ticket after you just killed somebody for speeding? It's hypocritical at its best. Okay. Liability or injury caused by a fleeing motorist or suspect. Sometimes people will run from the cops and maybe something bad happens. That actually happened to me. I saw some motorcycles and I thought they might be up to no good. They were sport bikes, so typically sport bikes act stupid. No, I say typically, sometimes they act stupid. So they turned, I followed them. I didn't think they saw me, and then I said, well, after about 4 or 5 miles, I'm like, well, I guess they saw me because they're doing everything right. I'm going to turn around and go back towards where I was going before. Right before I started to slow down and turn down, they all just go. And there was a Hayabusa, I think was one of them, so those things will do 200 miles an hour. No way I'm going to catch them. But I'm doing 120, 130, and they're just leaving me. Finally, I start to catch up with them as they get into the city limits of Iowa with the speed limit at 25, 35, school afternoon traffic. One of them goes through this intersection, at least 120, and at 383 at 90, and I'm like, this is fun, this is exhilarating. But I looked at it, and I guess I had just a little bit of wisdom. For whatever reason, I just let off the gas, picked up the radio in my car and said, look, I called, I was in pursuit. I said, hey, I'm terminating the pursuit. It's not worth it. It's just too much, So I actually passed a few of them that I clocked speeding, I got them on, they were doing like 140, but I got them actually on radar as I was passing them because they started to slow down to like 90 plus. So I pulled over and started writing tickets, and they were wearing Outlaw Motorcycle Gang colors. I can say which gang, but anyway, one of them was actually a police officer, and I couldn't believe that, wearing OMG colors. And I said, so since you're a police officer, I need to know who just ran from me. And he said, I'm not telling you that, and he surely didn't. But about 5 minutes later, I got a call that the one of them that ran was actually dead. So I said, well, I may not get all the ones that got away from him, but I'm getting one of them because he's up the road dead. It's a pretty unprofessional death notification, but I didn't know what else to say to the guy after he, literally a fellow law enforcement officer involved with that, people running from the cops, and anyway, so I went up there, and the guy had tried to pass like literally 12 cars. Doing, I don't know how fast, but he hit the back end of a turning sport utility vehicle, a Ford Explorer, which is basically a full-size SUV, and then made it rotate 180 degrees. The SUV rotated 180 degrees. The motorcycle just impacted it. but it was strange, but not strange. I figured out what happened. The front wheel, there was no damage to the front. So you're thinking, how's that possible? He had braked so hard, the first thing to hit the motorcycle, the first thing on the motorcycle to hit the SUV was his head, because he braked so hard, the back wheel came up and he just hit flat like that with the motorcycle in this position. So, and then of course he was what we call DRT, dead right there. And anyway, but there was no liability on me because I called it out. I said, hey, I'm stopping here. I'm not chasing this guy. It's not worth it. I didn't even make it to the intersection for which he went through because there was a serious possibility that if I kept chasing him, especially if I tried to drive like he was, that he was gonna wreck and hurt somebody or himself, and also I was gonna wreck and hurt somebody or hurt somebody else or myself. So it just wasn't worth the effort. Sometimes we just have to call those pursuits off. It's not worth it. So. And I've had to do that before in other cases. You just do what you can and catch them later. And I've always caught my guy, even if he got away on that same day. All right, liability for failure to respond to a call. There's really no liability in there, but you should always respond to your calls and do the right thing the right way for the right reason. And here's another one, liability for failure to arrest drunk drivers. There were times when, and an officer doesn't have to arrest a drunk driver, but if they do arrest them and they let them go and continue to drunk drive, that's where it becomes a problem. I mean, I live in the real world. You pull a cop over as a cop and you arrest them for drunk driving, you're going to catch hell. That's just the world that we live in. I wish I could tell you, oh, you got to do the right thing and arrest them. That's what you should do. That's what I've done. Even if they're politically connected, I would arrest them. But I tell you this, I would live to regret it because the next day I'm in the captain's office getting my butt chewed out for arresting the wrong person. They won't tell you that, but that's the way the real world works. Anyway, and I've also let people go. And when I say let people go, put them in the car, give them a ride home, get somebody to come pick up their car. There's no liability there because, who's going to sue? The guy that you took home, hey, he didn't arrest me for drunk driving. There's nothing to sue for. And who else is going to arrest you? Well, he didn't arrest him for drunk driving, and that could have resulted in a crash. Well, it didn't, so there's no civil liability there. And like I said, if I would have let the guy go, it would have been a different story. But here's something that's happened to me on a couple of occasions. I pull a guy over for speeding all over the road, whatever, and give him a field sobriety test and say, hey, you're under arrest for DWI. And I get them to the station, and I put them on the breathalyzer machine. They blow a 0.16, 0.2, whatever, some pretty high blood alcohol concentrations, double the legal limit sometimes. But whenever someone gets arrested, you get to search incident to arrest. So I search incident to arrest, go in the pocket, pull out a piece of paper. It's a ticket from 10 minutes before I stopped them. So they were drunk and got let go by another law enforcement officer. And I've had that happen several times. And some of them was my same agency, state police. I was like, hey, I get a call. Hey, I just stopped that guy. Why'd you arrest him? I said, because he's shit-faced drunk. That's why I arrested him. I can't believe you let him go. And then we just agree to say, well, he must have went to the bar between the 10 minutes in which you stopped him and the 10 minutes which I stopped him and drank a whole 15 beers, and that's what it was. But had that guy caused a crash and he'd been searched at that point and found the high blood alcohol concentration, that ticket in his pocket, that's going to be liability for a failure to arrest a drunk driver, or at least failure to get the drunk driver off the road. Okay. There's some lawsuits involving the police. There's a cool video, and if you look in the PowerPoint under current events, and at the bottom it's got the case video. Again, I've covered this once. I'm going to say it again. In this particular case, this guy gets stopped. I forgot his name. He looks like Drew Carey. But the guy gets stopped in Ohio, and the police say, I'm going to give you a break. I'm going to give you a warning. So here it is. And, oh, by the way, before you go, do you have any drugs or guns or anything like that in the vehicle? Of course, the guy says no. He says, well, do you mind if I search? And the guy says, well, I do mind if you search, and am I free to go? He says, and the officer says, well, yeah, you can go, but the vehicle's going to stay here. I'm going to detain the vehicle long enough to run my dog around it. And if you remember, how long did I say you can wait on the dog without reasonable suspicion? 0 minutes and 0 seconds. So they pat everybody down, pull them out of the car, run the dog around it, and then they search the car, and they also search the car and all that. And this was after the officer concluded the traffic stop. The guy stayed on the side of the road for an entirety of about 40 minutes. That resulted in a $100,000 settlement. So they're making this expensive. They're sending them, the civil courts are sending messages to police departments. You have to do it the right way. You cannot detain somebody waiting on the dog, unless you have reasonable suspicion. We talked about that before. Now, here's the good news. There's some, I say good news. Police officers are protected under what's called qualified immunity. So if it's not a clearly established constitutional right and the police violate it, they essentially can, they're not going to be held civilly liable. That's just the way it is. I don't agree with this. I think you should just evaluate each case on the merits, or they are trying to get rid of it, but right now it's in place. For example, when the taser came out, it was new technology to me. I worked a long time without a taser and was eventually given one. But the taser was always said, this is non-deadly force. This won't kill anybody. It's never killed anybody in the history of its existence. Okay, great. So we used it as a non-deadly force method. Now later on, they learned the taser will kill you. If you use it repeatedly over and over again, especially in the area of the heart, it's going to cause the heart to stop. Although it won't be effective in electromuscular disruption. So like if you hit me high in the body and low in the body, the current has a long way to travel. It's very effective. I've been tased before. I had to get tased on State Police SWAT. Not a fan, and it works. But if the prongs are far apart, it doesn't work. So repeated use of the taser, they learned over time that it can kill you. So one of the last cases, which is a few years ago, the courts finally said, okay, this officer killed somebody with the taser, repeated use of the taser, but he's not going to be held civilly liability under qualified immunity because it wasn't clearly established constitutional issue that the taser is deadly force. And they said literally in that case, and this is your last warning, this is now clearly established, the taser is a deadly force methodology. And if the next officer that kills somebody with it by repeatedly tasering them over and over again and it not getting the result you're looking for, you're going to be held civilly liable. So that's kind of covered by qualified immunity, but then now it's clearly established that that's not going to be okay. So just like the advent of computers, used to we could search computers without a search warrant. Search anything you sent out in an email without a search warrant. It was okay. But now it's considered secure private information covered by the Fourth Amendment, clearly established. So therefore, that would be any search of that without a warrant would be unconstitutional and clearly established and not allowed qualified immunity. Okay, you have something called vicarious liability. So like field training officers can be held civilly liable for what the person they're training does if they allow it to happen or fail to train them or fail to supervise them or train them the wrong way. The leadership of an organization can be held civilly liable for failure to train and stuff like that. Just like if they fail to tell their officers, hey, the taser is now considered deadly force, that could result in not only liability for the officer, obviously it would fall under the department and the departmental leadership. That's known as vicarious liability. All right, so that wraps up civil liability. That wraps up my last lecture for the course. I did do this course. The lectures, I usually do them in person. They're much more, we'll say, fun, interactive when I can get questions and stuff like that. But if you do have any questions, email me. The reason I did this is because, one, the COVID-19 situation, and the second reason is because Lake Charles, Louisiana was hit by a major Category 4 hurricane. My house was hit by 150 plus mile an hour winds, so not completely destroyed, but significant damage and collapsed ceilings and stuff like that. So I evacuated a couple days before the storm and remain evacuated until further notice in Cancun, Mexico. Poor me, right? So beautiful tropical environment, and I'm going to live here until until things stabilize back home. But I'll leave these videos up. So we'll say it's a historical memoir on why these videos are actually here and why we're not doing this class in person. Plus, I know the students in the class need this. A lot of the online students need this. So here we are. If you have any questions, email me. Good luck in the course. Do your best on the test. And if you need, I wish you the best. Thank you. Bye.